Okay. I'm going to be presenting the first part of this regarding disability process for public safety and corp. And then Trustee Moore and Stan Hoover will be doing their part of the presentation also. I always like to note the statutes that are in play with a disability. I don't expect everybody to know this. I tend to know it off the top of my head. I've been doing this for too long. But I always like to note them because they do come in handy. And plus, there are other resources that are on our website, the Model Uniform Rules, Local Board Retirement Manual, and the retirement spreadsheets. This is the statutes for public safety, and these are the statutes for corp. Again, you can find them on the website, or you can always email me if you need to know, which statute is directing what with questions regarding disability. So I always like to explain it that a member should be partnering with a local board secretary, because we're still using those retirement spreadsheets that we have on the website. And the local board does need to work with the member in order to start that application. It's a 2-page application. And that 2 pages, while not every bit of information from the retirement spreadsheet input page goes onto that application, there's still, that local board secretary still needs to use that retirement spreadsheet as the disability moves forward, whether it's approved or denied. So once that application, again, it's 2 pages, signed by the member and dated, and signed by the local board and dated. And that starts the 90 days, which it's specifically noted in the statute that the local board has 90 days with which to meet and review the disability. Now, it doesn't mean you have to do everything with it, but as long as that member's made application, you should at least acknowledge that you've received this application and now, we're waiting for medical records or something, but at least get it mentioned in minutes, that way you meet those 90 days. The retirement spreadsheets, again, we're still using those, and those are on our website under Forms and Resources, Employers, and Retirement Spreadsheets. That is the only place to find the application for the disabilities. And you would click on the button for which type of disability the member would like to make application for, and it should populate all those forms at the bottom of the Excel spreadsheet. If it doesn't, it could have a hiccup. It's old, like most of us here, or like me, I should say, sorry. And it's a matter of clicking on normal retirement again, and then clicking on that disability one that the member wants to make application for. Corp has the 3 different disabilities. Accidental and total and permanent are work-related. Again, that's important to know for Tier 3 members on the DC, because that's what's available to them. Tier 1 and Tier 2 do have the ordinary available, which is non-work related. Public safety has accidental, catastrophic, temporary. Those are the 3 work-related disabilities. And ordinary is non-work related. And just kind of keep in mind, temporary is just for 12 months. It is a temporary payment that is made to the member. And the member still has to make application for an ordinary or an accidental at some point during that temporary time period or after it's completed.
Joann, if you could, for the group here, if you could just speak to the ordinary disability and the years of service where it kind of cuts off, because I get questions from time to time in my role as a sworn local board member, who's eligible for the ordinary.
Thank you. And I think I do mention it, but thank you for bringing it up. Ordinary disability is available to members who have not met normal retirement. Says when you think about it, an ordinary, because it's non-work related, is taxable, and so is a normal. So once a member reaches normal retirement, that ordinary disability is not available. I did find recently, because I learn things every day, new things, temporary is also not available once a member reaches normal retirement. Once that 2 pages of the application is completed, please email a copy to localboards@psprs.com. It's just those 2 pages. We need to be notified. That's due to the statute change that occurred last year, but we need to be notified within 10 days. We're just tracking that information and just making sure that everything is following timely. And again, the Tier 3 DC members can apply for the work-related disabilities, even within the first 90 days of employment. So you got to keep that in mind, that they do have that option. And when it comes to the disabilities, the definitions are in statute, and they're listed there, which is good. But within each one, they do note that it's total and permanent. I think the only one that's different, it notes total, the temporary is total and temporary. Timely application is key. That is part of the statute requirement. Either the application is received after the disabling event or received within 1 year after the date of termination, and that's key. If that member waits too long to make application, then the local board could deny it because they've already exceeded that 1 year time frame from date of termination. Medical support. Is there enough medical information that the board can review in order to appoint that independent medical doctor? So that's key also, because sometimes the member might only get so much, or, and they're still kind of waiting for medical records to trickle in. There are a couple ways. When I talk to members, I always just suggest that it's quicker and easier if they are able to get those medical records and submit them to the local board. But page 2 of the disability does have the option for the members to initial that gives authorization for the board to request those records. Eligibility, the board should have those pre-existing, pre-hire information. So is the condition pre-existing? Or again, does the member qualify for a normal retirement? Then again, if the member qualifies for a normal retirement, then the ordinary is not available. And also the temporary. At this point, as long as the board has all the information and they can review it, the board needs to appoint a medical board. The board would work with that medical doctor, set up the appointment, provide the information to the member. The medical board will do their part in meeting with the member and provide back to the board some sort of report and answering the questionnaire. So the other part of that retirement spreadsheet, to make sure you click the correct disability the member is making application for, is to be able to get that questionnaire, the appropriate questionnaire, so that the doctor can do their part and the local board would do theirs afterwards. So the local board needs to review that information and, based upon the IME report, decide whether they can award it or deny the disability. Medical board. I'm always going there when I get questions about the board, the medical board, or the IME doctor. Constantly, because I need to be reminded from time to time too. The medical board evaluates the member's eligibility for disability. Designated physicians working in a clinic or a physician. But it needs to be independent, so that way the board can get information that they need to hopefully make their decision without any sort of impact from the members' doctors or from the employer's doctors. And again, the IME doctor will send that report to the local board and the questionnaire also. So the physician needs to be a medical doctor for injury, a physical injury, either a medical doctor or a DO. Mental condition, it still needs to be a medical doctor that does review this information. any other type of doctor, a PhD, or whatever, we do kick those back to the board and ask them to have an MD review the information and meet with the member and provide that report. Let's see. It's important to sign and date the forms on page 2, because not only is it start the 90 days, but it helps us know if that disability needs to be retroactively paid. What's submitted to public safety, it's going to be the application, whether it's the P5EE page 1 and 2 or the C5EE page 1 and 2. The form P5 or C5LB is all about the local board telling us that it's been approved and when it should start. The questionnaire, the IME report, and the minutes. And these minutes would be very helpful if you do more than just say approved or denied. We're kind of at a loss when we go to review this information. It'd be nice to have a bit more substance to it, so that way we know what was behind the thought process that the board approved or denied this disability. Again, there's resources on our website under Forms and Resources and Employers. And the disability documents, once they're complete, can be emailed to the benefit app at psprs.com or approved retdocs at psprs.com. That goes straight to our retired members department, so that way they can get that information sent, situated so that I can go through the review process on our site. Any questions?
So in your review process, when we the board, complete the hearing and we send you the board's recommendation, all the information, you said that there's a review process at the PSPRS level. Do you notify the local board once you complete your process that you're done, you've finished the review process, everything's okay? Or if we don't hear from you, we assume that it's okay?
If you don't hear from us, then it's gone through the steps that it needs to get that member set up for payment, and for that month that they're effective. The retired members department takes all that information, they go through the review steps, and then they immediately move on. As long as it's been reviewed and it's okayed, they're going to move immediately on to get that member set up for payment as soon as possible. And with all the other retirements that they're impacted by, it's challenging for them to reach out. So that is something I can certainly consider and help them with as we go forward.
Thank you.
Hi, Joann.
Hi.
So earlier you mentioned about pre-existing conditions. So when we talk about PTSD claims, what if there's no pre-existing conditions on file, but the medical records note a possible existence of PTSD while in military service prior to the member becoming or coming over to PSPRS? Is there any recommendations, any case law that you're aware of, or how are other boards managing that?
I don't know if these two individuals would like to help answer that question. I would appreciate it.
We'll start with this, Stan, and I'll go. Take the first shot. So, I've served on a local board since 1998, and that was kind of before we heard about PTSD issues. And I started out as the civilian member of a local board. That's how I got involved in this. Little did I know 25 years later I would be serving on the board of trustees. So it's been a long time learning process. In 2006, I became a sworn elected board member of the biggest fire member of the system, the Phoenix Fire Department local board. And we've seen a number of PTSD cases. We've denied some, and we've approved some. Just because there's an existence of a pre-existing condition, and it could be an orthopedic pre-existing condition of a particular limb that they're now applying for a disability retirement benefit on, you kind of look at, what's the relation, and this is where your independent medical physician examiner comes in and relating to this. I wouldn't say from a military perspective, if there's a PTSD case, they develop PTSD based on, the work as a firefighter. It's going to be based upon what the board looks at, what the medical information shows. I think what we do is we require pretty extensive treatment before they come before. We've had some applications that are 6 months after an incident, and there clearly has not been ongoing medical treatment, because I've attended a number of different seminars on PTSD that have been provided to our board on education, and some of the things they've said is that it's treatable, okay, and they possibly could come back to work. So we, in Phoenix, on the fire side, we've required, an extended period of treatment to make sure they've gone through the entire, all available treatment, and then look at the medical records if they're finally at the end and they haven't been able to return to work. So I know that's not a straightforward answer, but it comes down to the board decision. But like I said, that's how we've approached it. We don't take an initial application and say, we'll start processing it. We look at the medical information, how long they've been in treatment, what the results have been, look at the professional notes, because obviously there has to be, professionals in the specific disciplines treating it, and then, go from there.
So let's remember that post-traumatic stress disorder is a temporary condition. It can be permanent, but it starts out as a temporary condition. With the appropriate counseling and assistance, that person can go back to work. We expect they can come back and be a fully contributing employee. If it was a military situation or incident, it very well could have been temporary post-traumatic stress disorder, and then they've come back to work for you, and now there's another significant event that's not military. I would say if the guy comes in and says, I've got PTSD because of my military experience, that's a different explanation. But a serious incident of fire or a use of deadly force or something that happened to you, if it's just like if you had a pre-existing injury to your leg, but you had another serious incident to your leg afterwards, you wouldn't count that pre-existing condition as an exclusion of sorts. So as Brian said, you kind of need to sort it out by doing your homework and listening to it and that sort of stuff. I guess the answer is it's not an automatic disqualifier, okay?
My question is also for accidental retirement and pre-existing conditions. Who determines what is considered pre-existing or that happens on the job? So if I myself had a high school injury, I hurt my knee, I had surgery on my knee, recorded instability, I get hired, I have a couple events with the same knee, and now I feel I can no longer perform the job of a firefighter. Is it the local board's determination that my injury that's causing me to retire is because of a pre-existing condition or an event that happened on the job?
Well, that's where the, medical information is going to be key. For example, when I review an applicant for the benefit, the first thing I look for is the pre-existing medical form in there, and then I start looking through the rest of the medical record. If there's some indication in that pre-existing condition that there may have been treatment outside of the workplace, you're allowed to ask for those medical records as well. But that's where it comes down to, the evaluation, what the medical record shows, what the history of the injury was, ongoing care and treatment that they received. There's not an automatic exclusion just because it's pre-existing. That's why there's a 5-member board, 2 are sworn, who can bring the view of, working in the field, what the, workplace and type of mechanism injury that the applicant was subjected to. But it comes down to the board and reviewing that medical documentation. I've had some cases where the injury clearly was related to the pre-existing condition and, denied it, and then others that, it was an injury to the same body part, but the mechanism and type of injury was, completely different, and thus awarded the benefit to them.
It'd be fair to ask your independent medical exam too. If you take an observation and say, hey, it shows that he hurt his knee in high school, he worked for me on a fire truck for 17 years, never had an issue, now there is one. And that IME may just separate that for you, say, no, this is a new traumatic incident, you know, that sort of stuff, so.
Yes, the IME is, really critical too, so. What, are we
Okay.
going to cover more of ours?
Yeah, I think we
Okay.
roll into ours now.
We on our
Yes,
segment?
I'll let
Okay.
you all go with your part of the presentation.
Good. Okay.
Do we need the introductions anymore?
I don't think we need introductions. Just, as I
Wait,
told
just
you,
your name.
I was up here before.
Oh.
Brian Moore, I beat up the board chair with my crutch earlier. He says the crutch is from him beating me up, but we'll leave it at that. Hey, I've been serving on a local board since 1998. Started out with the fire district, Daisy Mountain Fire District. That's how I got involved in this, and it kind of progressed. And I was elected to the Phoenix local pension board in 2006. And with that, we've seen plenty of different disabilities, both catastrophic as well as accidental, of awarded ordinary disabilities, as well as line of duty death survivor benefits to family members. So that's where I picked up a lot of this. It's a continual learning process. Joann kind of scared me when she threw up the ARSs, all that are up there. I thought if there's a test on that, even I'm not going to pass it, but I know how the process works, and I know exactly what we have to follow. It's also really important that you have legal counsel with you when you're going through any kind of a benefit process, that they're experienced and that they're independent, meaning they're not contracted with your fire district or your city. They're not a employer attorney for the board or the city council or the mayor. Has to be an independent attorney, but they should also be experienced. And that's been the key to our success and what I feel is making good decisions over the long term. Stan has a lot of experience. I'll let him tell you about himself.
I'm Stan the Man Hoover, former crime fighter extraordinaire. Yeah, I'm living in the past. That's okay. I did 36 years with the Phoenix Police Department. 23 of those was on the elected pension board member thing. So I had 12 different assignments, from internal affairs to special assignments unit to patrol to whatever to recruitment. So I don't have the listing that he has. I'm just an old retired guy. I guess the best thing I thought, what can I add on there? So I got 7 grandkids, but that doesn't count for anything. So that's probably just good. So we're here to kind of talk about building a record for you for review. So click us
Here's our
up on the
clicker
next
here.
one. Oh, bang it up. So Brian touched a little bit about this, is you should have an attorney. We highly recommend you work closely with your board attorney. I still have my board attorney's phone number in my phone, and I call them every couple of months with a question that comes up to me. So if you're a board and someone makes an application to you, we want to help you understand how to build a record for future legal review, because it's not a trial, it's an administrative review where all your records go in and get reviewed. So you need to work closely.
Stan, if I can interject for just a second. So starting at the very beginning, one of the things I want to emphasize is, well, let me ask first, how many sworn local board members are here? Raise your hands if you're a sworn local board member. Okay. Sworn, meaning you're, a police officer or firefighter sitting on the board. Okay, good. How many civilian local board members are here now who, by, your capacity is the mayor or fire district board chair or civilian member, whatever? And then how many HR folks are here that serve as local board secretaries? Okay, we got a really good mix here. One thing I want to emphasize, and this is from my experience too, is that under state law, the sworn local board members, they're out working with these folks, both on the law enforcement side and the fire side. And under the state law, it's your responsibility to convey information regarding, PSPRS and the process to them, because the members are kind of confusing. It's a bewildering process, and I get frequently calls all the time from guys that have significant injuries and they've reached a point that they know they're not going to be able to get back in the workplace and want to know what their options are. So the sworn local board members, I want to impress upon you that under state law, it's your responsibility to give these folks some information, because I've had folks that had a significant knee injury, but they come in and they apply for a catastrophic disability retirement. They don't meet that requirement. I ask them, why did you apply for that? They go, I don't know, no one told me. So, it's important, and we'll figure it out and sort it out at the local board level. But one of the things I want to emphasize is just make sure that educate your folks on the process, or you get questions. You were elected to that local board to be the person or persons to help the member out. And we have a really good educational, robust process, both from YouTube videos, from classes and conferences and local educational programs that we give around the state, more so than what it's been in the past when I first got on this board, these local boards 25 years ago. So please take advantage of those. Thank you for your service, the civilians especially, those that serve on the 2 local boards. If you have a city, a municipality, a police and fire, I know the heavy lifting you have to go through because you got to sit through a meeting. Us fire folks get to leave after our part's done. The law enforcement gets to leave after their part. But you're serving on a local board and you do both law enforcement and fire. Thank you for that, and it's a really important job and service. So, sorry to interrupt, but
No,
continue on.
I agree 100%. So let's
Start the process.
Start the process. An applicant submits an application and his documentation. So some people will walk in and give you 1 or 2 pages, and some people will bring in half their industrial record. I know with Phoenix and other places, they go out and kind of help them do a research, and they hold their hand and walk themselves through it. The application and the documentation with it, the application is the applicant's burden. You, HR, don't have to go do it. He may need assistance, or you may have to get records that are withheld because of certain rules or regulations, but it's his or her burden to make the application. Once you get an application, a local board accepts the application packet for review. In other words, it's been accepted by the board secretary and put on the agenda. So the question comes up, can a board secretary not accept an application? And we had this question come up in Phoenix. And the answer is no, because the board secretary is just a conduit to get the paperwork on there and get it on the agenda. If you're going to tell somebody they don't qualify for a pension or a benefit, it's the board that's going to tell them to do that, not the secretary. So I just took something off all the board secretaries. I took that off your shoulder, okay? When in doubt, agendize it, put it on there. So can they accept or deny that initial application? Sure, that's part of your responsibility. You're going to look at the record. Do they have an injury? Did it occur in the line of duty? Does it totally and permanently prevent them from doing a reasonable range of duties in your opinion and observation? And if the answers are yes, and you think there's a complete medical packet there, okay. But if the accident was off duty or there's a glaring thing in it, and you say there's no reason without stopping it before you send it any farther and say, hey, we don't think that this one covers it, and you can actually deny one in a very early process. Have you done harm to the applicant? No, because they have an appeal right and all that sort of stuff. So the other thing is, for those fire and police people and even HR people, is there or are there industrial packets of past, prior, and current history of this injury? Boy, today's day and age, there's records everywhere. 25 years ago, 30 years ago, sometimes there were handwritten records and stuff like that. But I think that your employee knows where to find their records. And if they don't, they know where to go to their employer or city HR to find their industrial record, and they'll help them get that.
Absolutely. And if there's a personal medical records related to the condition that you're not seeing, but there's some indication that there was some kind of pre-existing incident, you can request those, and you can hold up the process until you receive the information that you need. I've been sued before. In fact, my board at the time is now in case law because we had a member that applied, and there's some bullet points down here at the end on what is their work status. Well, this person clearly had an injury that occurred in the line of duty. It was clearly a disabling condition. It was clearly going to be permanent. His problem was he came back to work on his last day of employment in operations. And he, in the city of Phoenix, it led to some confusion where our city requires that you have to be at work on your last day. Well, it wasn't really defined. He was on light duty. Somehow he got released, I don't know how, to his workplace, in operations, driving a fire truck. And he then applied for an accidental disability. We denied him because the attendance record showed that he was at a fire station on his last day. Now, it wasn't a really busy fire station, but nonetheless, he was in a vehicle that had 2 switches, I tell folks. There's a switch for emergency lights and there's a switch for a siren. You shouldn't be there, okay? You're not going to meet the requirements, okay? So we denied him. He got a lawyer, he appealed, there's appeal rights within this process. He then sued us, went to Court of Appeals and became case law that we made the right decision, because it clearly says your last day of employment can't be in operation. So I felt bad for him because he had, an injury. It's permanent, but, the law is the law. We have to follow it.
That's a good example of working with your attorney. I mean, there's, you can always go into executive session and start questioning your attorney about, hey, do we do this, or what do we need to put in the record so that we can defend our actions? Do we have enough, or that sort of thing? Don't be afraid to ask your attorneys questions. You're paying them good money. They should give you good answers most of the time. So Brian, address your definition of stationary.
Okay, so this is one of the other things. We'll have members that clearly have a surgery or something that they're not going to come back to work, okay, but they have not completed the medical process. I tell them, hey, we don't want to hear from you. We're going to table your application until your doctor says you're stable and stationary and reached maximum medical improvement. Then we'll talk to you, because that way we know that it's clear that they have permanent impairments, they're going to have permanent restrictions from being able to come back to work. Even though I know, and I'm pretty medically knowledgeable, that certain types of the spinal surgeries and so forth, they're not going to allow somebody to come back to work. But we wait till we get the word from their doctor, hey, there's nothing more I can do for you, you're stable, you're stationary. Sometimes it's 2, sometimes it's 6 months after that, but that's what it is. When they have permanent restrictions is essentially, the line in the sand that I go by, and I try to convince our board to go by when we receive that, nothing sooner.
So I suggest to the applicants that they have to understand what stationary is, and it's really good for the board if the doctor articulates that this guy's as good as he's going to get, he's probably not going to get any better, and in fact he may deteriorate or have degenerative issues. So you can't leap tall buildings in a single bound or jump off a fire truck with a big hose. It's over with, folks. And if that's articulated in medical terms or whatever in the record, it makes things easier for you as a board member and a board to move this thing forward.
And as a local sworn board member, one of the things I educate our folks on, because they come forward and say, hey, I've reached an end, I think I want to leave the workplace, even though they could continue to get some medical care and treatment. I tell them, you got to tell them what retirement and health insurance costs are. You could be spending $1,500, $2,000 a month, and when they look at what their accidental disability pension is, and they got a house, they've got kids, mortgage, tuition expenses and so forth, they really should know about that ahead of time, because I've had folks that applied and been awarded, and all of a sudden they get that accidental disability pension check, and then they see what their health insurance cost is, and they're like, wow, this is an eye-opener. So that's one of the other things that you should take into account. But we got to kind of zip through this from a time. You want to get to the last bullet point in there, because I like your story in the past on.
Yeah. So I kind of developed this. You can't be working on Monday and be disabled on Tuesday. And we had a gentleman come in and contact me and says, oh, I sprained my ankle. It's like, oh wow. He says, yeah, no, I'm getting treatment. He says, but I'm going to apply for an accidental disability. It's like, oh, okay. I can't tell you no. You can fill out the paperwork, do whatever you want to do. And so he comes in the next month, and the agenda's got him agendized, and we're like, okay, when did this happen? He says, oh, it happened such and such, so-and-so. Well, what are you doing? Well, I don't know. My doctor just did this. Have you been through any sort of rehab? What's the end result going to be here? Are you going to? So I don't know. It's like, well, you're not stationary. We don't know that. There's no medical record here. You sprained your ankle. By your own term, you sprained your ankle. We denied it. Well, he retired because he had his 20 years and went to work for a private corporation. So he was just trying to get his accidental disability tax-free thing from there. So you can't be working on Monday and be disabled Tuesday. So this is what light duty does, and I realize it's difficult for the smaller jurisdictions, but the benevolence of the organizations that put people on light duty and carry them through their injuries and stuff like that, we got to be very careful that you don't come back to full duty. I mean, if you're really, really broke, you can try to come back to full duty. If you can't do it, the doctor has to say you can't do it. So it's the old phrase that people can't predict their own disabilities. I always tell them, they say, hey, my doctor says I'm disabled. I need to take my disability retirement. I said, well, good for you. It's what the 5 people say at the board. whether you get your disability or not, and it's your doctor's records, not his doctor's decision.
He didn't tell the whole story, because what I wanted him to say was a motor officer that rode up and said, hey, I want to apply, and Stan looks on.
We did have a motor officer walk in, and he drove his motorcycle down there from shooting radar beams on Broadway and looked us in the face and said, I want to retire because I've had 5 accidents. It's like, well, how'd you get here? I rode my bike. Well, what are you doing? I'm working.
It doesn't happen that way. It doesn't work that way. Hey, a couple key points I want to mention too along this. The industrial injury system is completely separate from PSPRS. Okay, they're completely separate systems with that. And I just want to mention that you may have somebody that's denied on the industrial injury system because it's actually an unlevel playing field here in Arizona. I mean, you have different providers. You have insurance pools, you have insurance companies, you have self-insured, the independent medical examiners that are used on the worker comp side. If you end up having one of those used on your pension board side and you're looking at it and it's just not making any sense. I had one IME that came back that said it was obviously written by a worker comp provider because we had a guy that had some serious orthopedic injuries. He was not able to climb any ladders. It was one of the restrictions or whatever. The IME came back and said, well, maybe if he's given a small ladder, he'll be able to do some of the jobs of a firefighter. So that's one of the problems with our IMEs, and the industrial system is completely separate from the PSPRS benefit system. So just kind of keep that in mind, and you gotta take with a grain of salt the IME exams that are done on the worker comp side. They can help and they can hurt the applicant, but I've been part of a board that has awarded accidental disability retirements, even though they were denied care and treatment for some obscure reason on the worker comp industrial side. So just make that clear.
So I know we're running short, so let's go over this one real quick because I do want Brian to cover the cancer slide that we have at the very, very end here. But if you're not getting what you need, talk to your board attorney, okay? Do I have the right to these records? Can I get these records? Where might they be? If you're not getting what you need, ask the board chair. If the board chair is an employee of the organization, they should understand the HR process and how to get that information. Talk to, for the civilians that are on the board, if you have a question about firefighting, equipment, tactics, movement, or injuries, and how much that pack weighs when they put the air tank on, or how much a bulletproof vest weighs with all their stuff hanging on the utility belt and that sort of stuff, ask the elected board member. And better yet, if they have a Citizens Police Academy, go to that. If they have a fire academy, go experience what these guys go through on a regular day. If you're not getting what you need, you have the right to go seek it and ask for it. Talk to the chain of command, talk to payroll, department heads. Ask the applicant, are there any personal medical records related to this? We had a person who had a car injury with a back injury and came back 10 years later and wanted a disability, but had a sealed Superior Court record on a rather generous settlement from a very large corporation in town for a lower back injury. Did we give that person that disability? We gave an option: unseal your medical records or your court records, and we'll further your application. Well, the application got tabled and ultimately denied. The burden of proof is on the applicant. If you're not getting what you need, make a decision to try to go find it. If he's not participating or she's not participating and not giving you the information you need, you can't make a decision. So you can table it for a while, work with your attorney. How long do we table this? Or you can say, I'm not getting and what the information I have, I'm going to deny this. Okay?
One other source of confusion along the lines of industrial injuries is that I'll get a phone call from a guy that says, hey, I had my elbow surgery. The doctor says I have a 9% disability. Am I eligible for a accidental disability retirement? Well, I just saw the guy at a fire and I saw him throw his air pack, so he's clearly, in my view, wasn't disabled. But that is what's confusing to some folks, because you have an injury under the worker comp system, you get an impairment award, and it's usually some percentage of a disability. It does not equate to an accidental, an ordinary, or any of the disability retirements. Is completely separate. But I'll have folks call me up and say, hey, I've got a 10% disability. Am I eligible for a disability retirement? No, you're not. Okay, kind of depends on, what the injury is. Permanent restrictions in the workplace of your job classification and maximum medical improvement. Just remember, those are, where you start considering, are they eligible for any of the PSPRS disability benefits?
So the law takes into account for the fire and sworn people, fire and police people out here, the law takes into account that you will have possibly some intimate personal knowledge of this injury or occurrence or situation. So we had a gentleman apply for an accidental disability with our department, and as soon as it got put on the agenda, I ended up getting a note with a photo from another officer on the department, and the note was, hey, how can so-and-so get an accidental disability when he got MVP award in the softball tournament last week? Guess who asked him about his award? Guess who didn't get an accidental disability? Now, I know that never happens with the fire department, but,
No.
but every firefighter that wants to be an investigator, raise your right hand and swear at me, and we'll let you go investigate your firefighters that aren't telling you the truth. Because they have to tell you the truth in the applicant process, okay? So.
There's another point to that I wanted to mention.
Go ahead.
Skipping
Or does
my
old
mind.
age get you?
Yeah, the old age has gotten me. So along those same lines, let me also point out that who in here knows what the most expensive disability retirement is? Come on, someone. The most expensive PSPRS disability retirement.
What costs your employer the most money?
No, it's actually the unfunded one, okay? So somebody in Tier 1 that hasn't reached 20 years of service, or somebody in Tier 2 or Tier 3 that hasn't reached 25 years of service, okay? Anything beyond those dates is just a tax advantage to the employer if they get, or to the employee. But still, you can't give out tax breaks to employees without possibly affecting the PSPRS tax status that Diane McAllister spoke about earlier that allows us to provide the benefits that we do. So the most expensive disability retirement is those that are unfunded, meaning somebody that has 5 years on the job, 10 years on the job. I look at all disability applications very, very closely and very, very seriously. Those I look at even more closely to make sure, because that's essentially an unfunded retirement, because the employee hasn't paid in the system and the employer hasn't paid in the system. That's what costs money. So those are really critical to know what those differences are. So we're going to talk quickly about cancer. So there's no presumptive for PTSD. There's no presumptive for cancer in PSPRS. It's considered a workplace injury, okay, that is decided by the local board. But it's all based upon, documentation, as we talked about building a medical record, meaning it's somebody that's been on the job for over 5 years, because the industrial law for presumptive cancers is 5 years, and the reason for that is research has shown without any previous exposure to toxic carcinogens, which incidentally, the IR Committee on Cancer, which is part of the World Health Organization that reviews carcinogens, now has classified firefighting as a Class 1 carcinogen, meaning just like cigarette smoke and other things, meaning that your exposure to toxic smoke as a firefighter, puts you in the Class 1 carcinogen category, okay? But anyway, so you have to have a record of exposures, okay? The Industrial Commission for them to, or for under industrial, it has to be 5 years. So typically, so you have to have a record of exposures, going to fires and so forth. That's one thing. Secondly, a diagnosis of an injury, which would be cancer. And then you don't necessarily have to have an approved industrial claim, because some industrial systems, insurers, are denying claims and so forth. They're sending them to IMEs that are without education training in cancer and the stage of the development and so forth. So you don't have to have an approved industrial claim for any of the benefits under PSPRS, but you should look at those files and see what they say. I like this. Fire services are much better at exposure documentation than law enforcement. Firefighters, statewide are excellent on documenting, exposures to smoke and toxic carcinogens. The thing that's necessary in the IME exam is that the IME doctor for the pension benefits, not worker comp, I'm talking about the pension benefits, is that more likely than not the cancer came from firefighting. and you have to have an independent medical examiner. On the cancer side, I will tell you that they are difficult to find. I've found that I've worked with a lot of folks within the Phoenix Fire Department and statewide who've had occupational cancers. And most oncologists, the majority of them, all they do is kind of treat you like assembly line medicine. You come in, they prescribe a regimen of chemotherapy treatment, you move along, you come back for a visit. I've asked every one of these folks universally to ask their doctor about, some kind of statement for, their workplace involvement and exposures. The doctor looks at them like they're from Mars and says, I don't know what you do. I don't know what is involved in firefighting. So it's real difficult even from the treating doctor to get that information, unless you're seeing some specialist that understands now that the IARC, International Agency on Cancer, has classified it as firefighting as a class 1 as it relates to carcinogens and the toxic exposure. Okay, so when it comes down to getting an IME that knows that information, I will admit we've had challenges within the city of Phoenix. Now, there was a question earlier about, hey, will you hear back from the fund if you make a decision, if they're going to tell you to reconsider it? Yeah, so that's a correct answer. You don't hear anything, hey, everything's good to go. I've been on the end where they've come back to us and say, you got to rehear this, okay? And they give us usually a reason why. One of them was a cancer case, because we got a really vague and ambiguous answer from an IME doctor on a case, and we ruled that, hey, we've got this other documentation on studies that basically said, yeah, this cancer came from this guy's occupational exposure, and PSPRS said, no, the doctor has to say that. He didn't come out clearly and say that. So ultimately what we ended up doing, rehearing it, we sent them out to another IME, and that IME, now we have 2 IMEs, and the local board has the legal ability to decide which IME they want to select as, for the benefit. So we went with the other one that we had, the secondary one that was clear and concise on, that particular subject. So, not a presumptive, but it's something that the local board, has to consider and process. Any questions on that?
Good, because if we haven't confused you enough, let's talk about COVID-19, okay?
Okay, not enough. There's no presumption for COVID either. There's actually no presumptions in the PSPRS, but because of an exposure to duty-related, resulting in an injury or death, and we've had a line-of-duty death in Phoenix. We've had a line-of-duty disability that we approved because there's a clear, distinct causal relationship with their exposure, either inside the firehouse or on an emergency call, that we approve those benefits. The key thing is documentation and ultimate diagnosis. You should go back and look at the entire record. Hey, where was this person? What kind of contact did they have? Did they actually have a COVID patient? And then you have your options with these types of applicants is, hey, you don't think it's work-related, you can deny it. If the individual has long COVID symptoms, and we're seeing a lot of them, they can't come back to work to the workplace. They have permanent restrictions. So here we go back to that stationary, stable, permanent restrictions. They can't work on a fire truck, or they're unable to work as a police officer. But it looks like it may be outside of employment, then you can consider the ordinary disability. Remember, the ordinary is for folks that have not reached the retirement age. They can't get an ordinary disability if they have over 20 years in Tier 1, 25 in Tier 2 and Tier 3. Line of duty death or not, that's some of the things you have to consider with this whole process. We do know that both on a nationwide level and even here in the state of Arizona, firefighters and police officers are on the front line every single day, working in tight quarters with folks who had serious COVID cases, especially early on, before the guidance, direction, and PPE came out. And we've had a number of folks, both within a significant number in Phoenix Fire Department. One of them died. We awarded line of duty survivor benefits, and as well on a statewide basis. This has affected both police officers and firefighters on a statewide basis by these exposures and subsequent inability to return to the workplace because of pulmonary, cardiac, and other related issues.
If you were on vacation in the Caribbean for 2 weeks and came back with COVID and then it went downhill for you, it's probably not work-related. But there's enough documentation and things that occur on the street that if you and your chain of command or HR go back with all the medical records and the shots that people have had and that sort of stuff, you should be able to put together this puzzle and figure out whether you're going to make it the system's responsibility or it's just an unfortunate illness to the applicant.
Now, the federal government came out and said, you're probably familiar with the public safety officer line of duty death benefit. It's around $400,000 now. They said with COVID, if you develop COVID within the 45 days of your last shift work and you died, you're eligible, providing you submit all the required documentation to the Department of Justice for that line of duty death benefit. And they have a whole, stack of COVID cases that they're processing the Department of Justice for that public safety officer line of duty death benefit. So it may not have been an approved pension case in their jurisdiction. It may have been denied on the worker compensation basis, but the federal government, looked at it differently for public safety employees.
Good.
We don't want to be in the way of lunch, but if there are any questions, we'll take them. Otherwise, you can grab us at lunch. Thank you for your service and everything you guys do on the local board level. It's greatly appreciated and makes a difference.